Hello everyone. Today our Group 1 will delve into Article 10 of the Malaysian Federal Constitution. Article 10 safeguards essential rights, which is the right of freedom, assemble and association. It is vital for democracy, however, it is not absolute. It permits restriction for national security, public order and morality. Now moving on, we will break down for the explanation of Clause 1. Clause 1 affirms the citizen right. Think of it as an foundation for democratic participation. It confers the citizens to the right to speak, assemble, and associate freely. For Clause 2, this grants Parliament the power to restrict Clause 1 rights. It provides flexibility to address societal consideration like national security and public order. It is a delicate balance between individual liberties and border social needs. And for Clause 3, laws can restrict the rights to form association, especially in labor or education. It's about maintaining discipline and ensure the smooth functioning of a workplace or educational institution. And finally, for Clause 4, this is crucial because the Parliament has the power to enact laws penalizing acts that incite or violence or disturb the public order. It is about balancing free expression with preventing harm to society. And moving on to the restriction for these clauses. To sum it up, Parliament can impose restriction for various reasons. One of them is for national security, public order, morality, and so much more. However, this balance raises concerns. There have been discussion about the potential limitation on citizen participation in public affairs imposed by the Malaysian government.
Now, before I explain the Malaysia Sedition Act, there are two other acts that correlate to the Article 10 of the Constitution. Now, the first one is the Printing Presses and Publications Act, or which is known as PPPA 1984. It is a law that regulates the printing presses and also the publications and imposes restrictions on the freedom of the press and also the publications in Malaysia. Now, the second act is called the Communication and Multimedia Act, or which is known as CMA 1998. Now, it is a law that regulates the communication and multimedia industry in Malaysia by covering a wide range of issues related to communications, including licensing, consumer protection, and also the management of network facilities. Now, let's go back to the Sedition Act. The Sedition Act is a very old act, 1948, and it has been used to prosecute individuals for alleged seditious statements, which has led legal challenges related to the freedom of speech. Now, there are many examples that can relate to this act, but the keyword to highlight here is called seditious. Anything that is seditious or which promote ill-willing feelings and hostility that can inflict conflicts, it is considered seditious. Now, under the Section 3, Clause 1, it has been stated that a seditious tendency is a tendency to bring hatred against any ruler or against any government, to excite disaffection against the administration of justice in Malaysia, and also to promote feelings and hostility between different races or classes of the population of Malaysia. Now, let's talk about the case that relates to the Article 10 of the Constitution. This is a case about Mat Suhaimi bin Shafee versus the public prosecutor. Now, the appellant has been charged under the Section 4, Clause 1 of the Sedition Act 1948 for the offence of publishing an article containing his views towards the law of the Constitution of Selangor 1959, which were to be seditious. However, the appellant pleaded not guilty and claimed trial to the charge, and before commencement of the trial, the appellant filed a notice of motion to the High Court and sought for the criminal prosecution instituted against him. Now, there are some issues to be noticed from this case. The first one is the Section 4 of the Sedition Act was actually inconsistent with the Article 10 of the Federal Constitution and was therefore void and invalid. Now, the second one is the Act did not comply to the Article 10, Clause 2A, and could not be objectively to be said a reasonable restriction. So it did not actually fulfill the objective, and it was wholly disproportionate to the valid reason permitted by the law to restrict the fundamental rights of the appellant. Now, these reasons has caused the High Court to acquit and discharge him, as the charge could not be sustained. Now, in conclusion, the Sedition Act is a very good act. as it helps to preserve peace to our people. Now, Article 10 is about freedom of speech, but the Malaysia Sedition Act is just an act to impose and restrict some seditious expressions. It's just to restrict and filter the sedition expression or someone who's promoting feelings of ill will or hostility towards anyone or towards the government. So this act is actually a very good act, and it helps to bring a peaceful environment to our country.
Assalamualaikum warahmatullahi wabarakatuh, Dr. Mariam. My name is Abang Azli Razman bin Abang Ahmad, and I have chosen the Printing Presses and Publication Act 1984 as the act that I would like to discuss on. So the question of the day, the question that I'm sure have been in your thoughts before, does Section 8A of the PPPA violates Article 10 of the Federal Constitution? So to answer the question, let me present to you a case study. The case can be referred in Public Prosecutor against Pan Cheng Chun. So the case centers around the prosecution of Pan Cheng Chun under Section 8A of the PPA for allegedly violating restriction on freedom of expression. So Pan Cheng Chun challenged the constitutionality of these sections, arguing that they infringe upon the fundamental right to free speech, and this case has three issues. The first issue talks about restriction of free speech under Article 10, subsection 1, clause A, by Section 8A, subsection 1 and 2 of the PPPA. The second issue discusses whether limitation in Section 8A, subsection 1 and 2 align with permissible bound in Article 10. And lastly, the examination of overall consistency of Section 8A, subsection 1 and 2 with Article 10 to establish constitutionality. So, the Supreme Court, after careful consideration, ruled that Section 8A, subsection 1 and subsection 1 of the PPPA is constitutional and valid, falling within the permissible restriction on free speech outlined in Article 10, subsection 2, clause A of the Federal Constitution. The court clarified that Section 8A, subsection 2, presumption of malice does not amount to pre-censorship, ensuring that press freedom is not unduly restricted. So this decision established a delicate balance between protecting free speech and preventing the irresponsible spread of false information. That's all from me. Thank you very much.
Assalamualaikum, my name is Nur Alia Sarah, and I will explain the next act that fall under the jurisdiction of Article 10. The Communication and Multimedia Act 1998 served several purposes, including the regulation and management of the communication and multimedia industry. The relation between Article 10 and CMA lies in the potential tension between constitutional freedom of speech and the need for regulation in the industry. While Article 10 provides the freedom of speech, the government, through legislation such as CMA, may impose certain restriction on certain form of speech or communication in the interest of public order, national security, and other valid reasons. So, Section 211 and Section 233 under CMA 1998 deals in the improper use of network facilities, where it prohibits the transmission of offensive content with the intent to annoy, abuse, threaten, and harass any person. The offence may be punished by a fine up to 50,000 ringgit and or imprisonment not exceeding 1 year, or both upon conviction. So, CMA addressed emerging digital issues such as cyberbullying, online harassment, protecting consumer protection, and most importantly, national security against terrorism-supported content, malicious and hatred to secure public order. Therefore, I want to highlight how CMA 1998 became the balancing act for Article 10 in digital landscape, because it helps to strike a balance between individual rights and also societal interests by providing a legal framework that allows for the responsible exercise of freedom of speech, even though it is a constitutional right.
For conclusions, Article 10 of the Constitution plays a pivotal role in fostering a democratic and inclusive society. It underlines the importance of freedom of speech, assembly, and association. It also serving as a cornerstone for open dialogue, diverse opinions, and the free exchange of ideas. It also promoting transparency, accountability, and responsiveness within the government as it empowers citizens to voice their concerns and opinions. However, this fundamental right is not absolute and can be subject to restrictions in the interest of national security, public order, and morality. Malaysia has enacted various laws, including the Malaysian Sedition Act 1948, the Printing Presses and Publications Act 1984, and the Communication and Multimedia Act 1998, as balancing acts for Article 10 under different aspects. The Malaysian Sedition Act criminalized seditious speech, potentially stifling legitimate dissent, while the Printing Presses and Publications Act grants the government to control over the media. The Communication and Multimedia Act regulates the online content, raising concerns about freedom of expression in the digital landscape.